Laurie was a theatrical promoter in London, and Carroll promoted shows in Australia. They had discussed the possibility of bringing the famous ballerina Dame Margot Fonteyn to perform a limited season in Sydney and Melbourne. Correspondence went back and forth, but the progress was slow. Williamson Theatres approached Laurie with a more definite plan, and the tour went ahead without Carroll's involvement. While Laurie was in Sydney for the performances, Carroll sought a writ against him in New South Wales to order that the profits of the venture be frozen until Carroll's share had been worked out. No order was made, and Laurie travelled to the Melbourne shows. He then left for New Zealand, and Carroll sought a writ in Victoria, again to freeze the profits. The Chief Justice in Victoria gave an order for substituted service. This occurs when personal service of the writ on the defendant is not practical. The order allowed Carroll to serve the writ on the legal firm which had been representing Laurie. Laurie objected, saying that the Victorian court had no power to issue a writ against him after he had left the jurisdiction. And if they had no power to issue the writ, they had no power to make an order for substituted service of that writ. As the majority in the High Court put it, the defendant must be amenable to the command of the writ. His amenability primarily depends upon nothing but presence in the jurisdiction. The second question, though, was when he had to be within the jurisdiction. The court found that as long as he had been within the jurisdiction at the time the writ was issued, he was within the power of the court, even if he fled the jurisdiction before service was effected. Their Honours said, the issue of the writ is the exercise of jurisdiction over the defendant, and accordingly it is enough that he is then present within the jurisdiction. At that moment he may be regarded as falling under the command of the writ as an exercise of jurisdiction. If a defendant, knowing of the issue of the writ, goes abroad before personal service or goes abroad to evade service, doubtless he may be treated as under notice of the obligation of its command. In this case, though, Laurie had left Victoria before the writ was issued, so the Victorian court had no jurisdiction over him.